And we stand ready to hear the second case, excuse me, of this session, Dahnweih versus Iowa Board of Nursing. This is case 24-1764, Dahnweih versus Iowa Board of Nursing. We have Trent Nelson for Ms. Dahnweih and Breanne Stoltze for the board. Whenever you're ready, Counsel.
Thank you. Good morning, and Counsel in the court. This case is about a woman. She's a mother. She's an immigrant and a refugee, and formerly a nurse who she went to a state-approved school, a nursing school in Florida, to receive her associate's degree. The school is called MedLife. By the way, my client's name is Helena Dahnweih. I might reverse the name here and there because I mispronounce it often. But she went to class. She studied. She received a diploma, and she was accused by the Iowa Board of Nursing of being a fraud. The crux of the board's argument is that when my client, Helena, when she submitted her application to the Iowa Board of Nursing, that she knew that she did not have the required educational requirements that was needed to get a license in Iowa. This is simply not true. And our contention is that A, the Board of Nursing misapplied the standard of fraud, first of all, and secondly, that they didn't have substantial evidence to prove that my client committed fraud.
Counsel, is there any dispute in the record about whether Ms. Dahnweih completed that capstone course at MedLife?
That's a very good question. The Board of Nursing didn't even attempt to establish whether or not the credentials were, what she did at MedLife were sufficient to meet her educational requirements. They didn't even look into the substance of what she did. We provided evidence of that, but what they decided, this all came about from a investigation that happened in 2023. Now, my client attended MedLife in 2017. She applied.
One of the factors that the board cites is the overlap and the no explanation for the overlap between the dismissal from the Purdue program and the beginning of the MedLife program. Is there something in the record to explain that, or?
So there's nothing in the record to necessarily explain that, but from my client's standpoint, Ms. Dahnweih, she testified that until the investigator for the Iowa Board of Nursing approached her in 2023, she had never seen the transcript. So when she applied for a license in 2019, she had never reviewed that transcript. We also established that the board won't even accept a transcript from her. She is required to have MedLife send it directly to her. So when she actually saw the transcript in 2023, she acknowledged, oh no, this isn't accurate. I mean, she wasn't lying about it. She was being earnest and said, no, this transcript isn't accurate. But that's the first time she had seen it. So no, we don't have an explanation for why there are discrepancies on the transcript. We acknowledge that they're there, but my client had no knowledge of them. Fraud cannot be committed by accident or mistake. This is true for administrative proceedings as well. This comes right out of Sahu and Rosen, which I cite quite a bit in my briefing. There has to be an intent to deceive and a knowing perversion of the truth. And the evidence that the board relies on to say there was, it just isn't substantial, subject to Iowa Code 17A 1910F. And that, so the board's decision doesn't even rest on this intent to deceive, but rather that there were enough red flags in the program. And these are my words, I'm summarizing. Red flags during the one course, because the only course she had to take was this cornerstone course, that there were enough red flags during the course that she should have known that she was engaged in a fraudulent activity, that she should have known based on these red flags. Now, that's not the standard for fraud. It's not should have known. It's a deliberate and intentional perversion of the truth. And for Iowa Code 17A 1019F, for the evidence not being substantial, that basis is when a reasonable mind, so when testing the evidence that a board uses, the standard is when a reasonable mind would find the evidence inadequate to reach the conclusion reached by the agency. And so here's the evidence that they used to find my client. Oh, go ahead. Sure.
There also a reckless disregard piece of the fraud standard?
There is a reckless disregard. I would say in this particular case, and this is where the substantial evidence comes in, the kind of evidence that they cited isn't the kind of evidence that would say that she was somehow reckless. And the case of Rosen gets into that because this was a doctor who submitted his application to the Iowa Board of Medicine. And there's an attestation, that states that, I have reviewed this material and it's all correct. He didn't review the material. He just signed the document. And they said in that case that, oh, this was reckless disregard. But there is no such reckless disregard in this case. And I don't think there's substantial evidence to support a reckless disregard standard.
Factor in the board's credibility finding about your client when we're looking at that substantial evidence question.
I mean, obviously you have to pay attention to credibility. I mean, you have to defer to the fact finder on that. I don't think it makes a difference in this case. I think the problem is that they use credibility, their credibility determination, as evidence in this case. They state that because we don't believe her, she must have committed fraud. They still have a burden to meet. They still have to prove that her actions were fraudulent, and they didn't do that. So, of course, we don't like the credibility standard, but I don't think it makes a difference in the outcome of this case.
Can you help me with one thing? My understanding is she took a number of credits at Purdue, okay? And in fact, all but one class, essentially. And this class that she took at, I call it MLI, but the MetLife or whatever that is in Florida, that it was sort of a capstone class whose only goal was to prepare her to take kind of this national licensing exam, right? Correct. All right. And so to the extent that there was fraud that was needed or beneficial to her, I guess would be the way I would say it, it would be the credits derivative from this capstone class. Is that accurate? Do you understand my question? Because no one disputes that she legitimately earned the credits at Purdue. That's not in dispute. And so for whatever she needed to do with the state of Iowa, it essentially amounted to this capstone class, right?
That's correct.
All right. All right. And so all the credits that she took at Purdue are legitimate. We agree with that? All right.
I don't think there's any dispute about that.
So how would she benefit by having a transcript prepared that double dips on credits that she's already legitimately earned if she doesn't need it?
And when the investigator came in 2023 and said, here's the transcript, would you look at this? She said, oh, no, this isn't right. I only took the one course. I mean, she's acknowledged that through the whole thing. In fact, the Board of Nursing takes that statement and says she acknowledged she only took one course. Well, that's all she's ever said that she wanted to take, but they took that as evidence of fraud because she freely admitted that she only took the one course. And that's part of the reason why we're here today, is because she went to class. We gave evidence. It wasn't just her testimony that she went to class. We provided emails that required immunizations and required her to prepare and pay. We sent over 200 pages of study materials that she was sent with the email that they were sent from. I mean, there's no reason for her to believe that she didn't actually attend a class and get the credentials she needed, which is what they're claiming that she should have known, which again isn't the standard for fraud, but they're claiming she should have known based on these other red flags, which I haven't gotten to. But even the investigator in this case who presented the transcript to her said that she thought that Ms. Dahnweih believed that she had a degree, and that was the state's sole witness. So this claim of fraud is, not accurate, it's not supportable, and we're asking you to dismiss this case against Ms. Dahnweih. Thank you.
More time on reply. Ms. Stoltze?
May it please the court, counsel, Breanne Stoltze on behalf of the Iowa Board of Nursing. Before we get into the facts of this case, I just want to make sure that we've clarified what the standard of review and the fraud standard that we're looking at here, because I think both are extremely important in this case. As to the standard of review, even Sahu, upon which appellants rely, states that the question we're asking is whether there is substantial evidence to support the board finding the board actually made, not that it might support some other factual finding. This is relevant because it goes to this notion of, well, Ms. Dahnweih did take this NCLEX prep course, and the investigator actually discussed this at the hearing. That's at page 28, lines 1 through 11, saying, well, there's nothing wrong with taking a test prep course insofar as it goes, but a test prep course isn't a nursing degree. And the finding here was that there was either knowledge or reckless disregard that Ms. Dahnweih knew, or recklessly disregarded the fact that she did not have a nursing degree. That goes to that second point where we're not just looking at knowledge, but just reckless disregard. And that's essentially, was there any effort to verify what she submitted to the Board of Nursing was true or not true?
Wasn't her submission, right? I mean, it came directly from the school.
With respect to the transcript, the initial transcript that was submitted, however, that doesn't necessarily address the conscious disregard issue. The Board of Nursing investigator testified to that at page 47, lines 1 through 12 of the transcript, that yes, the transcript that the board receives comes from the university, but it's atypical for the school not to send a separate copy to the applicant beforehand, either formal or informally, to verify the truth of what is on that document. So that kind of, Ms. Dahnweih, I believe, testified that she kind of didn't know or didn't look into it, and that goes into some of the other credibility issues, because it's not just...
Will send a precursor transcript.
Not that I'm aware of, and this goes to some of the other, there were a lot of irregularities with things the school did send or did not send, and that any other typical educational institution would have sent, and that's...
Okay, fair enough, but I mean, isn't it speculation to say that, well, most of the times, these institutions will send a dummy transcript or unofficial transcript to the candidate at the same time or before they send the official transcript to the accrediting agency? I mean, isn't that speculative? And I guess that's my concern is, yeah, an anomaly maybe, but I mean, fraud's a pretty high standard here. And, if we don't know those types of things, right, that's a problem. That's a problem for the state.
I would say two responses to that. One is that there's this obligation when attesting to, whether something is true or false. There's an obligation to verify the accuracy. That's not only Rosen, but that's Hall v. Wright, upon which Rosen relies, and a line of Supreme Court cases really going back to 1918, that when you make an attestation that something is true, that there's some obligation to verify whether something is true or false. Ms. Dahnweih didn't do that. But then also, the board kind of made that finding that there was clearly some sort of conscious disregard as to what was in the transcript by not making even an attempt to verify it. And again, it's not just the transcript. There's a discussion. I would really urge the board to look at the transcript from the hearing starting at about page 127. That's where some of the board's questions of Ms. Dahnweih, where, for example, they're asking, if you look at her nursing licensing exam request or application to take that exam, that is something Ms. Dahnweih testified that she filled out herself. She selected as kind of the school she attended, West Palm Beach School of Nursing, even though she then testified, well, I knew I didn't go to West Palm Beach, I went to Naples. That's it. Those are different schools on the other side of the state. West Palm Beach is a school that in the record it shows closed in 2016 before Ms. Dahnweih allegedly would have attended. She also, didn't make any effort to ask, well, she didn't receive a syllabus or a course number for the capstone class. She was receiving, she had class dates to be determined, was receiving email addresses from not only personal email addresses, but different email domains. And all of that is especially relevant here if we consider the fact that Ms. Dahnweih didn't just attend MedLife and Kaplan. Prior to coming to those two schools, she had experience at 6 additional institutions of higher learning. And this was discussed in the hearing that she had familiarity with how these institutions of higher learning were supposed to be operating. And it wasn't just that there are these facts here, that she had no credible explanation for all of these kind of irregularities, which led to really the board's.
Still confused about, is there a dispute about whether she completed the capstone course?
I do not believe so. The question is then whether, though, she received a nursing degree from an institution. Yeah, the investigator talks about this. Again, that's page 28 of the transcript, saying there's nothing wrong with an NCLEX review in and of itself, but it isn't a nursing degree.
The evidence that that course didn't then complete her nursing degree.
Well, it was essentially that this wasn't an institution that kind of could have given her a nursing degree.
But weren't they in an accredited institution at the time that she took the course from them?
I'm glad you asked, because there's a considerable dispute in the record in this, because she was asked about, well, was there accreditation? Who accredited them? And the answers were kind of unclear, because I think there's a dispute or a question or a difference between state approval and accreditation. And accreditation occurs through kind of national organizations. So like you've got the Accreditation Commission for Education and Nursing, Commission on Collegiate Nursing Education. That is accreditation separate from state approval. And it seems that the school might have had state approval. However, if you look at the record, particularly some of the Operation Nightingale documents in the record, the school wasn't approved for online learning. So as far as kind of could that capstone have counted for a nursing degree, that's...
Provide flight receipts or tickets, stubs that showed she flew down for the course?
I'm glad you asked. I would actually encourage this court to look at those class schedules and and those itineraries. That's exhibits E, F, and G of the record. In particular, there's a lot that really doesn't line up with the scheduling. Sort of the dates in October don't match up as far as the days of the week in the schedule. Her flights out of Florida aren't consistent with having attended a class from 8 a.m. to 10 p.m. on Saturday. Some of the different kind of locations being flown into don't necessarily make a lot of sense. I think the board could have looked at those, and probably did, as well as some of the additional communications received when sending those transcripts, like the personal email address, the fact that there's a phone number that's actually for, Atlantic City, Jersey Shore area, not Florida, and kind of looked at sort of her lack of explanations for some of these things. So, whether she received she completed some sort of test prep course is separate from whether she received a capstone course or a nursing degree. And that's really the question before us here. And even then, if we're talking about, well, she completed the course, that kind of goes to a question of materiality, which one what has not been challenged, but also I would point the court to Rosen, and I believe it's page 351, where, yes, 351. In that case, there was no question that the doctor had completed the internship of which he'd set, or at an internship that would have satisfied the requirements for medical licensing. He just was inaccurate as to where it was received. And the Iowa Supreme Court said, well, that's still material because in the medical profession, we have issues where honesty and integrity when submitting these licenses is critical. So even if you kind of satisfy this, if there's a misrepresentation within your application, that doesn't kind of absolve you of any fault.
Take you back to the credibility question and the board's credibility finding. It looks like the credibility finding was really based on kind of what you mentioned earlier, that she had experience with a number of these kind of programs and should have been kind of tuned into the irregularities. But isn't that something we can look at too? I mean, it's not something that was solely within the realm of the board having her in front of them. Like we could determine whether that was credible based on her experience. Kind of an external credibility finding.
I'm not entirely sure about that. Certainly can kind of look at, yes, she had this other experience. However, the fact that there were multiple explicit credibility findings, the case law is clear that there's substantial deference given when a fact finder makes a credibility finding. That makes sense. The board not only heard Ms. Dahnweih testify, but also kind of were able to ask her questions and cross-examine her.
That's not what they base in the written ruling, that's not what they mention as far as finding her not credible.
I see my time has expired. My answer? The board, let's see, to look specifically, they did say, she claimed to have attended these secondary institutions, but there's also just the finding there where it says, respondent says she applied in good faith, obtained the required license, and separate from that discussion of the number of institutions, the board specifically said the board does not find those assertions to be credible. And those, if you look at the board's findings, those appear to be separate from the discussion of the institutions that Ms. Dahnweih attended.
Thank you.
Thank you. I do appreciate your last question as far as the deference to the fact finding, because there have been a number of cases where if it doesn't fit in with the special expertise of an agency or an administrative body, the court may not give as much deference, because that's the whole purpose of the agencies, to provide an expertise that the courts might not necessarily have. I just want to touch a little bit on when she took the NCLEX and she picked the different school. And she testified to this was a computer drop-down that had MedLife, but it only had one location. And she testified, well, maybe they only have one location on here because they have different satellite things, and she just accepted. She just hit what she knew she went to MedLife. So it wasn't some sort of intentional disregard. The state would have every applicant to nursing school apparently be familiar with all the differences between, what's an approved school, what's a accredited school, and to perhaps track down every single person, every administrator that may contact you through whatever means. I mean, typical applicants don't go to this level. They were familiar with. She said she checked with the state to see if the school was approved or accredited. She testified to this. I don't have a specific reference, but that's what she did, and that was good enough for her, checking with the state of Florida. To to presume that someone would do all this and still go to a school and go to classes is just kind of beyond belief. And so when we're talking about the evidence that they used to find her guilty of fraud, the first is that Helena negotiated the price of tuition. They told her that she'd have to pay a certain amount of money. She said, I'm only taking the one class. Is there any way we could make this a little cheaper? They agreed, and that's what happened. She paid tuition. That the administrators of this, well, they also stated that she had little to no classroom instruction, which just isn't true.
Can you respond to your colleague's point about the flight itineraries not matching up with the class schedule from the emails?
The class schedule from the email only had one set of dates, and I guess I haven't looked, this was not brought up during the hearing, so I'm not particularly familiar, and this is the first time that I've heard that there's a discrepancy. But she only had, well, there's two things going on. There was, the class schedule wasn't set in stone. So there was 3 months where she was to attend classes in Florida, and she was supposed to be there for 3 days, roughly amounting to about 36 hours of class. October schedule was set, but November and December weren't. I don't recall what flight itinerary we had, and also some of the information that our client had was limited because this was 5 years prior. So I asked my client to get whatever information she could so we could provide it as evidence. And that's what we did. So I can't actually speak to that because I haven't looked to see what those dates were. I just remember at the time we put just to show that she did reserve flights down there. And like I said, there was classroom instructions. Like she had 34 hours a month, roughly, based on that initial schedule that was sent to her. And she testified that she went. I know she didn't have credibility, but she did testify that she went to these classes and that she was on campus. This is more than most students would in a nursing program if they went locally. That the administrators at the school use personal emails. I'm not sure if I would even notice if someone used a personal email. And I think that to assume that she thought to assume that she should have known that this was an illegitimate program because they used these emails, it just doesn't make sense. It doesn't meet the standard. And it also doesn't prove that she knew that she didn't receive this diploma, because there's two levels here. They're saying she should have known based on this stuff, but also what did she know? And I see that I'm about ready to run out of time. On behalf of my client, this is more than just her career. I mean, this is her reputation. The press has caught this. They've called her a fraud and called her a liar. She's worked 30 years and she never took a shortcut to get her nursing degree, and she's worked hard to help people. And this is devastating to her. So I would please just ask that you dismiss this case. Thank you.
Thank you both for your vigorous arguments today. We really appreciate it. That we will consider this case submitted, and a written decision will be filed as soon as we can. Thank you.